It's 8 p.m. I think we'll start the class. Today we are going to discuss professional and practice year 2023 paper. It's going to be a very short discussion because we only focus on 4 questions today. So I hope you have this Legal Profession Act 1976 with you, huh? Because most of the time we have to refer to this particular statute. Right. Before we commence into the class, I just want to make a few disclaimers here. This is a pro bono class, and I'm a very junior person in law. And this class is just to brief you all regarding to the structures of professional practice part A section. And of course, since this answer is not an official answer from LPQB, I cannot guarantee the information of these classes, and certainly I do not have any conflict of interest with those parties that have formal classes to CLP students, and your feedback is very much welcome. Okay, so to me, sharing a little bit experience with you guys, I think PP paper is the toughest paper out of uh, 5 subjects that we have for CLP. Why I said so is because the varieties of laws being tested in this particular PP subject. We have ethics and advocacy. On top of that, we also have land law, and we have probate issues, as well as we have bankruptcy and also winding up of companies. So most of the time, it involves a lot of this detailed discussion into the specific areas of the examination. That's why to me, I think it's quite a tough paper as compared to the rest of the subjects in CLP. So you have to bear in mind that this particular paper, you will need to answer 5 questions. So you have very little time for you to actually think about the answers and then subsequently to put it into writing. It all comes with practice, and the answers that you are going to regurgitate during the examination will be coming from your natural reflex. So basically, what I'm trying to say is you do not have time to think, and it's very rushing, trust me. Okay, so these are the this is the proposed timetable for you to complete each and every question in PP paper. Do not assume that you can pass this paper by just answering 4 or 3 questions. It's impossible, ladies and gentlemen. You have to answer 5 questions. Even if you have answered 5 questions, at the end of the day, most of you might be surprised that your marks is just capped at pass. That means 40 over marks only they are giving you. So you can see actually the examiners for CLP are quite strict in awarding marks in nature. Okay, bear that in mind. Please answer all questions. Okay. And again, I will just try my best to remind the candidates to refer to statute first. Okay, please refer to statute in order for you to answer the question paper. Very important. Then only you support with relevant case law. This is not an English legal system. This is a Malaysia legal system. So we have ready-made statute which should be referred from time to time by the candidates. And you are expected to be highly familiarized with the statutes. Okay. So without further ado, we go to the first question of this year 2023 July paper. Okay, I'll just read the question out for those who do not have paper, don't worry. Okay, so this is the first question. Ali has just graduated with the degree of Bachelor of Laws with honors from University Malaya, whereas Mutu having spent the last 20 years in UK, just returned after having been awarded a law degree by the University of Nigeria. Okay, so when you read the question, you try to underline the keywords here. And Mutu has never taken any examination involving Bahasa Malaysia paper. So all this is actually key points here. And Ahok too has completed his degree and was called to Honorable Society of Lincoln's Inn, UK, as barrister at law. So Ali, Mutu, and Ahok are each of the view that he is qualified, okay, qualified, and authorized person under Legal Profession Act 1976 and at liberty to be admitted and to practice as an advocate and solicitor of High Court of Malaya. So what is your duty is being given in the question here. You are to advise Ali, Mutu, and Ahok separately as the status as a qualified person and unauthorized person and the statutory steps to be taken for each to be successfully admitted and enrolled as an advocate and solicitor of High Court of Malaya. So your duty is to advise Ali, Ahok, and Mutu in regards to the status, whether how do we define by law qualified person and authorized person, and also what is the admission procedures required for them. Okay, so for you to answer, you have to identify a few facts here. Salient facts that you can derive from the question are Ali is a fresh graduate LLB, okay, from University Malaya, whereas Mutu LLB from University Nigeria. Lepas tu ada Bahasa Malaysia qualification. And also Ahok is actually barrister at law lah. He was called in UK, Lincoln's Inn. So three parts of the question. First, define qualified person. Rely on your LPA. Second, talk about what is so-called authorized person. And third one, how to get admitted to be advocate and solicitor of High Court of Malaya. So your task is very clear here. And this question, should it come out in exam, please do, because it is very easy. Okay, as compared to the rest lah. So a qualified person, you can actually copy down from your section 3 of this Legal Profession Act 1976, whereby a qualified person means anyone possessed with the qualification as listed in A, B, or C, in which to say A, he or she has passed LLB of University Malaya, University of Singapore, that is before independence, because these two are actually the same, okay, the same, or National University of Singapore, okay, or B is a barrister at laws, okay. Take for example, the case given here is Lincoln's Inn. This is one of the criteria to be qualified person. Or C is in possession of such other qualification published in the Gazette and declared by the board to be a qualified person. Okay, take for example, all of us who are present today are likely to fall under category C because we have to take CLP. CLP. So CLP declared by the this LPQB, the qualifying board, to be qualified person. So this is all it means by a qualified person. Okay. And then there's a distinction between qualified person and also authorized person here, because the qualified person only enables you to get the entrance ticket to practice law. That means to say you are not fully recognized yet, but you have the prerequisite condition that can be called as advocate and solicitor in High Court of Malaya here. So having said so, you need to satisfy two conditions under this section 36 sub rule 1 of your Legal Profession Act 1976 in order for you to call yourself as an advocate and solicitor, or layman term as a lawyer in Malaysia. First of all, you must have the name registered on the role of advocate and solicitor. Okay, so the role here is no longer a physical role, but a computer system nowadays, registered with High Court of Malaya. Very important, eh? And second thing, he or she must have a valid practicing certificate. This one is issued also by the court. Okay, very important, huh? Okay, so actually, the law itself did not provide the exact meaning of what does it mean by authorized person. But Section 36 Sub Rule 1 LPA provides that if you do not possess these two criteria that I have told you just now, 1 and 2 together, you are deemed to be an unauthorized person. Okay. There are some news recently that raised some concern about real property agent, the real estate agent. They have actually giving their tenants and also landlords to facilitate them to prepare the tenancy agreement. So there's a statement by the press saying that doing so may amount to infringement of Section 36 LPA, and this is a criminal offense. Okay, just bear in mind, only advocate and solicitor can practice law in Malaysia. Okay, otherwise you will be caught as an unauthorized person. You attract fines and probably imprisonment. And the fine itself, I think not much also as compared to Medical Act. It's only 2,000 fine and also possible imprisonment. Okay, whereas if in Malaysia Medical Act, if you falsify, you practice medicine, the fine is 300,000 ringgit. Okay, so you can think yourself lah. And anyhow, making inference from specific provision above, so an authorized person is an advocate and solicitor whose name is on the roll and he has valid SAPC. Okay, the case you can refer to here is Ramanathan Value, whereby this advocate and solicitor did not renew his so-called SAPC, but he appeared before the court. Something like that. If let's say, for example, I have this is 2024. Every year I will need to renew my SAPC with Bar Council as well as the Court of Malaya. Actually, it's inside the same system now. Okay, so I must get 2025 SAPC before I can practice or appear before the court next year. So this is what it meant. Okay. So we'll examine the qualification of each and every individual given in the question in turn. Okay, first of all, so Ali confirm, he's a LLB from UM here. So he is a qualified person. Okay, under, please be very specific. He's a UM LLB holder, so he should be admitted by section 3 subrule A. Okay, so this is the provision that provide for the admission section 10 of LPA. Because he's a qualified person, he will get the entrance ticket. Okay, whereas Ahok here is a barrister at law of England. So the specific provision that you can use here is section 3 sub B. Okay, very important, eh? Okay, and you submit lah. The Hawk, sorry about the spelling, should be Ahok, as he's a qualified person. Whereas Mutu, you see Mutu, no doubt, he is staying in UK, but his primary qualification here is what? University of Nigeria. So University Nigeria, unfortunately, is not a recognized university by LPQB. So he is not even fit to sit for CLP. Therefore, Motu will have no chance at all. Be very firm since you know the facts. Okay, to be admitted as an advocate and solicitor in Malaysia, unless he takes LLB again in recognized university. Whether or not Mutu has no BM qualification, I think is not having any bearing for this question anymore because his primary degree is not recognized. So for you to save time, because the examiners required you to discuss Ali, Ahok, Mutu in turns. So you already did so. But having the similarities here, you can actually to save yourself some time because I said time is very, very important in this paper. So you can actually put your arguments as like this. Okay, since Ali and Ahok are both qualified person, their statutory procedures to be admitted as an advocate and solicitor will be discussed collectively. Okay, just as one lah, to save yourself some time because you are going to copy the same thing. I mean, yeah lah, you are going to copy the same thing lah for both Ali and Ahok. So I will further put that reading together section 14 and also section 11 provides the what we call how to admit as an advocate and solicitor, whereby Ali and Ahok should be at least 18 years old and have good character, meaning to say that they have no previous criminal conviction of any of this dishonesty or fraud issue, not being declared as bankrupt, and never bar in to practice as an barrister or solicitor in England, or disbarred, disqualified, or suspended from any country at all from legal practice. So these are the things that you must write. And he or she must be a Malaysian citizen or at least a PR, and also must complete 9 months of pupillage in Malaysia. Okay, all that actually you can copy from the statute, but I will really hope that because this question itself is not very tough for you to memorize, I would prefer you to actually remember those criteria by your heart so you can um, vomit them out during examination. So in furtherance, okay, so you must talk about the Bahasa Malaysia qualifying thing. So section 11 subrule 2, so you have to submit it. So Ali from local university. So but on top of that, Ali must also produce proof that he has at least a credit, okay, in SPM. Very important for you to get LPQB exemption from sitting a Bahasa Malaysia qualifying examination. If you get a F in in BM in your SPM, you will need to sit for one special qualifying examination we call BM qualifying examination done by LPQB. So this is one of the criteria. Same thing for Ahok, okay, we have seen some UK grads actually they are entering into those private school and all that, they do not have prior Bahasa Malaysia qualification. So during their pupillage, they will be called by LPQB to sit for BM qualifying examination. And trust me, BM qualifying examination also tough, Okay, quite tough, huh? And section 12 sub rule 1, both of them must undergo 9 months of pupillage unless it is exempted lah, unless it is some special condition whereby you have served the judicial legal service as a magistrate or DPP before. But this is clearly not the case for Ahok and Ali here. So 9 months pupillage, you are required to tag with a pupil master lah. Okay. The master must be in active practice for at least 7 years in private practice. Very important, active practice and also private practice. Okay, so this is pertaining to your section 12, sub rule 1. Okay, so section 12, sub rule 3 further said that during pupillage, they can only take remuneration from their master and cannot earn any money without special written permission from bar council. Okay, so this one very important. You cannot work as a Grab driver. You cannot work any part-time. Okay, during the pupillage unless you have declared the said to the bar council. Like me, as a mature student, I'm the directors of a few companies. I have to write, how to say, the statutory declaration to the bar council in order to get some permission or leave from them. Okay, so otherwise you might get caught for this. Okay, you can refer the case of Chi Kuat Lin against Majlis Perubatan Malaysia, whereby this he's still practicing now. Our learned friend last time, he was so-called, he was receiving the pension from Royal Malaysian Police, Police Diraja Malaysia. Okay, and he did not declare that, and somehow or rather, Bar Malaysia raised an objection towards his admission, to Bar. Okay, uh, very important. So when commence their pupillage, they should simultaneously submit their petition course paper. So this is pursuant to your section 10 and section 15 of LPA. So during pupillage, you have to handle course paper, petition paper. So in brief, because they ask you to discuss what is the statutory procedure. So for you to get a little bit, I always want to say something lah. You want to outshine your peers, you have to know something in practice. Uh, so these are the key words that those examiners, because those examiners are who, the judge, the senior lawyers, they know very well the law, Okay, so this one, Ryan, I potong, because these are all freshly prepared as answers by me. So there are some mistake that I will correct later lah. Okay, so in brief, Ali and Ahok must submit borang 1, 2, 3 to bahagian kuasa-kuasa khas High Court of Malaya, KL, for their admissions via e-filing system. This one only you know when you are undergoing pupillage because you are required to do so. Okay, that's why most of the people can only score 10 out of the 20 because whatever you know from books, may not be adequate or sufficient to impress the examiners. Okay, and in furtherance, they must also submit borang 4, 5, 6, which comprise of an originating summon and affidavits, one made by the pupil, one made by the master, to local High Court of Malaya to obtain a short call order. Take for example, me, I have to submit my paper to bahagian kuasa-kuasa khas High Court KL, and also I must also submit borang 4, 5, 6 to High Court at Johor Bahru in order for me to get called. So additionally, throughout pupillage, they were required to learn advocacy, knowledge, and skills from their master. This go without saying lah. Okay, they are also compelled to attend this ethic course because at the end of the day, the state bar will give you a certificate. This one is very important. One of the criteria, one of the exhibits that you are going to tender for your long haul later on. And you have to perform your legal aid duty. Okay. For example, we have a legal aid clinic in Johor Bahru court. You have to attend for continuously at least for 14 days. Okay. This is how is it. So towards the end of their pupillage, they must submit their borang 7, 8, dan 9. And when you submit all these for your long call, then three bodies, namely the Attorney General Chamber, the Pejabat Peguam Negara, the State Bar, for example, me, Johor State Bar, and also Malaysian Bar, they will look through your course papers as a whole. They'll scrutinize every details, and also they'll check whether you have criminal records or not. Then, if there are no objections by the three bodies, then only you can be called to the bar in High Court of Malaya. So, not finished yet. After getting the long call, they will need to register their name at the instrument of advocate and solicitor. After that, they must purchase professional indemnity insurance. After that, apply for seizure annual and practicing certificate. So after you have complete your long call and everything, you still have to follow other steps for you to be advocate and solicitor. Because for you to get SAPC, you must get insurance also. Okay. So after you have complete all the brief procedures as described, Ali and Ahok can practice legally as an advocate and solicitor in High Court of Malaya. It's not in Malaysia, lah, sorry. It's actually High Court of Malaya. We can only practice in the peninsula of Malaysia, not including Sabah and Sarawak. Okay, very important. So these are the brief. So this is what we call the instrument. So this mark as a so-called role lah, role. Because nowadays they'll return to you lah. This is the instrument that I have discussed with you, and these are the apa nama, the seizure annual and also practicing certificate. So seizure annual is issued by Malaysian Bar, and your practicing certificate, see, PC number, is issued by the Mahkamah. Okay, but this one together is being applied by the Bar Malaysia websites at one shot. Okay, at one shot. After you have got all these, then you can validly, legally practice as an advocate and solicitor of High Court of Malaya. Okay, as simple as that. Okay, we go to the next question, which I also recommend you to do if it ever repeat in your, coming July paper of this year. Okay, I will read the question too. Saroja has appointed OB, an advocate and solicitor from the firm OB1. You see, our examiners themselves, they are highly trained in Star Wars, all that one. One of them is a Star Wars fan. If you have noticed, sometimes you can see Obi-Wan, sometimes you can see the Skywalker, Luthers, and who else? Whether the name will come up. That means this question is coming from him. Okay, Star Wars fan. Okay, so in respect of the sale of Saroja's bungalow in 2019, so Saroja has been waiting for the payment of balance purchase price of 700,000 ringgit. So according to Saroja's calculation, the completion period has occurred, see, but OB informed her due to COVID-19, the purchaser has not paid the full purchase price and must be given extension by law until December 2020. So during the MCO period, the government did announce a period of moratorium to to complete the so-called SBA because the law firms are prohibited from practicing during that material time. So this is, I suppose, this is a real existent case lah. Okay, so Saroja by chance met the purchaser in a wedding function and was informed that full payment has been made to OB firms back in December 2021. So Saroja's contact OB's firm, but was informed that OB is no longer working with the firm and cannot be traced, so absconded. The firm informed Saroja that the sum of 700,000 is no longer in the firm's account. So alamat lah to this client Saroja. So Saroja here is anxious to know the following. So she's interested to know what is the compensation fund is all about. And Saroja seek your advice whether she could recover in full her costs from the compensation fund. Okay, 5 marks. So we are examining the sub question in turn. Okay, so A, answer to the question 2A. You will need to define what is compensation fund. So you can refer back to your statute where section 80 talks about compensation fund. So the compensation fund is basically a collective pool of fund whereby all the practicing lawyers in the whole Malaysia, when they want to renew their SAPC annually, there's some additional fee or contribution that we need to give a few hundred ringgit. We need to contribute yearly to this so-called tabung, okay, compensation fund. Okay, so actually the purpose is to mitigate the loss suffered by the members of public who are the clients of the lawyer's clients arising out of the dishonesty of lawyers. So this fund is not for any other use except to compensate the clients who suffer losses due to the misappropriation of fund by certain black sheep lah in our legal fraternity. So because legal fraternity is should be highly respected by the society. So don't here and there got somebody, black sheep run away a great sum of money, hold as a holder fund by their clients, and then every time got reported in newspaper. So not nice, isn't it? Okay, so these are the compensation fund all about. Okay. So second part of the question, how you want to get this how to say this compensation funding is you briefly, again, to outshine your understanding as compared to your peers, you demonstrate a wider reading and also a clear and deep understanding on how this thing work. You use this advocate and solicitors compensation fund rules 1978. Okay, first you have to file form A and B together with the schedule of particulars to be annexed to form A and B, and you must do a SD, and you must provide the Saroja's contact details form should be complete. And then you have to submit to this compensation fund unit of Bar Council Malaysia. Okay. So briefly, one glance here, talk about this. And then you have to back to this question, you have to back to the question whether she can get the money 700,000 in full or not. These are the second part of the question. If you answer this only, how to say, compensation fund, probably you'll be entitled to 1.5 mark. If you answer little bit more by referring to Rule A of Advocate and Solicitor, Compensation Fund Rules 1978, probably you can secure a 2.5 or 3 marks. So these are the strict approach by the examiner. You must really I mean you must be really outshine and uh, bright and smart lah for them to give you 4 or 5 marks. Okay, so referring to Rule 8 of the said rules, okay, the bar council may, before deciding whether or not to make a grant out, because compensation fund, all the lawyers are actually paying for it, so they have to scrutinize the application well. So they'll consider a few factors. Number one, whether Saroja could have a separate civil remedy against the OB1 and firms, as well as to OB in personal capacity or not. So this is the apa nama, first consideration. The second thing is whether there is already a criminal proceedings ongoing. So to verify it is the loss due to the section 420 lah, usually section 420 lah, cheating lah, tipu duit lah. Okay, is this dishonesty or not that lead to the loss? Okay, or making an application to DC or not, this whether this Saroja complain or not about this matter. Otherwise, you cannot simply draw out the fund from this compensation fund. Okay, so based on the facts here, Saroja would likely to have a fraud or negligence claim against Obi-Wan and Call, which sounds like a soap prop lah, because it names after them, after him. Okay, so you because the facts is not adequate, so this is my personal submission. Okay, so there could be an issue of apa nama, contributory negligence on her part for not exercising due diligence, because the facts say that she actually know, she calculate when the completion date, but why do you let the loss happen without due diligence, without checking whether the stakeholder money shall be released or not? So therefore, you put your stand lah. If you kesian with Saroja, you can submit that he will get full compensation. But I rely on the facts that she never checked. So I will submit that Saroja would likely to get partial compensation from the fund, but not in full. Okay, there's no right or wrong answer, so long your answers is logical and also reasonable. Okay, so this is my answer for this question 2A. So for your enlightenment, this is form A, form B. I feel that actually by looking at those course paper, it actually helps my memorization better rather than just uh, copy and cut from the books. You will forget tomorrow. I will encourage you to look at the course paper to get the practicing part out of this, because every question they ask is pertaining to day-to-day practice. So this is your schedule of particulars to be annexed. So what is the money all about? What is the circumstances? It's about a SPA bungalow thing. So you have to list down the criteria. And this is the SD and also compensation fund contact details form. Okay, these are all in the relevant bar council website. You can have a look. Okay, so we go to question 2B. What is it? So question 2B warrant the discussion of what the professional indemnity insurance of an advocate and solicitor entails, and whether Saroja could claim from the insurance company directly for her losses. Okay, read the question super carefully. Okay, please, because they are always, if the question is too, I mean, too easy lah, sometimes they will divide into several parts. So when you miss a part, you lose a lot of marks. Okay. So question 2B, professional indemnity insurance, what is it? And whether she can claim directly or not. So my answer is as such. Again, you can find from the section 78A of your LPA. So actually, professional indemnity insurance was a mandatory proviso. Like I've said to you, before you can apply for this SAPC, you must subscribe to a professional indemnity insurance. So this is pursuant to your section 78A, okay, of LPA, and whereby Bar Council had maintained a mandatory professional indemnity insurance scheme. So every single lawyer or law firm in Malaysia are actually subjected to the same master policy. The Bar Council Committee, they have some insurance committee, I suppose. Okay, they will discuss with the MARSH lah. Now it's all MARSH Insurance Company. They'll discuss to fine-tune this master policy where all the members must subscribe to the same, okay, master policy. So why do we have this professional indemnity insurance? Is because to insure its members. This is to protect lawyers from civil liability for claims arising out of the legal practice work. Okay, customarily and legitimately performed by lawyers in Malaysia, which include damages payable to claimants, including claimants' costs and defense costs. Okay, very important. This is because lawyers could be caught as negligent. So whenever negligence should occur, we as a lawyer, we also need to defend ourselves in the court. If we lose the case, professional in our professional capacity, it is on our personal liability, That means if I lose the case, I was found to be negligent towards a client, I will need to sell my Rolex, my car, my house, my shop, whatever assets that I have. So in order for this to be prevented, or there is a so-called risk stratification strategy, the insurance is my shield. Whatever arise, if it is within the so-called uh, premium or the policy amount, okay, let's say I have insured myself 3 million ringgit. If it's within 3 million, I have to pay the client for my own negligence. The insurance will pay for me. As simple as that. So that is to protect the members of the bar against civil liability. Okay, so this is the first part of the question B. And second part, if you can still recall, can claim directly from insurance company or not? The answer is no. Saroja will still need to commence a civil action against OB for fraud or negligence first. If OB was found liable, then the insurance company will make the payout. So you conclude saying that Saroja cannot claim directly a loss from the insurance company. So basically, from my understanding about this question, you have, if you have done so, you have answered two parts of this question 2B. Okay, so 2C, we'll look at 2C. What is it? Whether OB's conduct amounts to a misconduct. Okay, so pretty easy, huh? Okay, so how do you want to make your answer slightly better than the others? Okay, so you go to the meaning. What does it mean by misconduct in the first place? You can get your answer by referring to your statute, section 94 subrule 3 LPA. So misconduct basically means that it is a positive act, that means a conduct, or an omission to act, negative act, done by an advocate in Malaysia or elsewhere, see, which amounts to grave impropriety. Something wrong lah, yang kesalahan yang teruk lah. Okay. So the list of misconduct was actually provided in subsection A to O of the same provision, because the question asks you to discuss directly to OB punya misconduct. So you briefly define, you know already. This is the first part of the question. Ask you how to, what does it mean by misconduct? So second, you go to the question whether OB's conduct amount to misconduct or not. So you have to submit as follow. In this case, OB had fled away with client's money that he was holding as stakeholder. That one is not his legal fee. That 700,000 is actually his holding, the purchase money for the client. So first part, he could be actually convicted for cheating under section 420 of Penal Code, tantamount to an infringement under section 94 subrule 3 subrule A. That means criminal conviction, that is dishonesty and all that lah. Okay, so on top of that, he also breached Rule 7 of your Solicitor's Account Rule 1990, that is drawing the money from client's account for his own purpose. So that one also breached section 94 subrule 3 and subrule C of your LPA. And then you conclude, it is crystal clear that OB's conduct amounts to misconduct for sake. Okay. So 2D. Okay. 2D, what is it? Whether she can lodge a complaint against OB with the disciplinary board and what orders that the board may make. Okay. So this question pretty simple. First two questions better do lah, if like that. Okay. So as discussed in answer 2C, okay, because you don't want to repeat and be redundant, no point. Okay, so you can use similar sentence as I have drafted for you. So OB had committed a misconduct under section 94 rule 3. You can put general or you can put A or C that we have discussed. So as an aggrieved party, Saroja can lodge a formal complaint against OB. Okay, because OB is a lawyer, isn't it? So to where? To advocate and solicitor disciplinary board. Okay, remember the place to lodge a complaint is ASDB. Okay, this is an independent board separate from the Bar Council. The chairman is actually one of the retired judge, and the members are those very, very senior and reputable members of the bar. Okay, it works entirely independent, ASDB. So pursuant to your section 99 of LPA 1976. So Saroja, again, this is something practical because in real life, they are, how to say, they are lawyers that cheat clients, to put it in a very plain and straightforward wordings, whereby you as another lawyer, you would need to advise the clients to lodge a complaint against your own colleague, Very sad, but this is the reality. And she will need to furnish the disciplinary board with the following documents. Okay, so first of all, she will need to complete the so-called complaint form, as in ASDB website. There is a separate website. And again, she will need to do a statutory declaration. She'll need to give her IC and also what are the supporting documents of her complaint. And more importantly, because I have said to you, SDB is an entirely an independent board separate from bar council. They need operational or administrative fee. So this is 200 ringgit. The client who complained must pay 200 ringgit. Okay. So after the complaint, the procedure, because you are not required to discuss so much, you just need to go to the question and show your understanding about that. So do not discuss or there will be a DC meeting lah. DC will decide whether got merits or not, then submit to the DB for ultimate ruling. No point, no point. Okay, just briefly, 1, 2 sentence to show that you know lah, to show off a bit, you have read about this legal profession, in bracket disciplinary proceedings rule, the latest one, 2017. So pursuant to section 94 sub rule 2 LPA, should OB be found guilty of misconduct, so the DB may actually impose one or more, one or more of the following penalty or punishment. Number one, to be struck off the role. Number two, to be suspended from practice for not exceeding 5 years. To be ordered a fine, okay, not exceeding 50,000. To be reprimanded or censured. Warning lah, okay. So considering the culpability and severe nature of OB's misconduct, it is likely that OB will get the the heaviest penalty or punishment, in which, if I were you, this case is very clear here. You run away client's money, there will be no forgiving from the DB. In practice, this is memang like that. You run away client's money, you get struck off from the roll. Okay, no excuse. Okay, and you can refer to the case of Chong Yik Sen against Majlis Peguam Malaysia. So submit like this. Okay, we go to third question. Okay, 3A. You are required to relate your answers to both parts of the question to ethics and etiquette of the legal profession. Okay, so Buntu, an advocate and solicitor practicing as a sole proprietor of Messrs. Buntu Chambers, is being sued by a licensed money lender, Saudagar. He then filed an appearance through his firm. Okay, see, so an objection is being raised by the solicitors for the plaintiff on that particular appearance. Okay, so Buntu then decided to request his wife, Chante, who is also an advocate and solicitor, practicing as sole proprietor of Messrs. Banger and Co., to take over the conduct of the brief. So Messrs. Banger and Co. shares the same office and telephone numbers with Messrs. Buntu Chambers. Chantek has previously acted for Saudagar in many other briefs for loan recovery. So discuss Buntu and Chantek's conduct in the above situation with reference to rules of ethics governing the legal profession. So 10 marks, Okay. So how do you want to tackle that? Do not just discuss about Chantek. I know Chantek is very, very obvious here, but do not get too excited. You must read and analyze the question very well before jump into answering, because once you answer, sometimes there are people that it's just like a train, non-stop writing. At the end of the day, when they double check their answers, they realize they missed of the important ingredients of the question. So first issue is about Buntu. So Buntu actually, what he did, he represent himself. Okay, it is well established principle lawyers should not act as counsel and witness in the same proceeding. This is by right lah. Okay, so you can refer to one case here, that is Emperor against Dadu Ramu, where it is expounded by Beaumont Chief Justice. An advocate cannot cross-examine himself, nor he can use to address the court as to credibility of his own testimony, and a court may feel that justice will not be done if the advocate continues to appear. Uh, this is something like, if let's say you are the lawyer, but at the same time you are the defendant. So you as a defendant, you have to cross-examine the plaintiff, and then you have to re-examine yourself back at the end of the day. So there is possibility this sort of scenario can give rise to embarrassment in the court. So that means to say you are playing too many roles. So usually, if your your professional capacity, you especially as a lawyer in the future, you get sued, it is better to engage a third party to avoid this sort of embarrassment or awkward condition that can arise during the due process of the court. Okay. So in the given scenario, Buntu or his firm, so see, was sued by moneylender Saudaga. So by right, Buntu could not represent himself as he will be the main witness, the defendant of the suit in a professional capacity. Okay. But however, this is just for critical thinking lah. But I put it in red do not submit like this. How about litigants in person? That means self-representation. Does it work? But in my humble opinion, you better don't write so. Yes, no doubt, if you are being sued as a individual in Malaysia, by right, you need not to have a lawyer to represent you in the court if you know what to do. But the conflict here is at the same time, you are also a lawyer. So that means to say you can do without a lawyer. But then if you are a defendant, at the same time, you are a lawyer in this condition, it cannot. But to be safe, payah buat pandai lah. Payah buat pandai. This one is just for uh interesting discussion. But whereas if other person, if they are not lawyer, ordinary layman, they can go for litigants in person. Okay? But since the question had been tuned in a way that he had breached this ethic rule, so please don't commit yourself in such a manner. Okay. So second thing is about Chantek. So Chantek's represent Buntu. You have to highlight what is the LPPR rules 1978 in brief. So rule 3 talks about embarrassment. Rule 4 talk about the professional conduct is likely to be impunged. So rule 5 talks about the difficulty in maintaining the professional independence. And rule 7 talk about pecuniary interest. And rule 28 uh, cannot appear in a case where he's believed to be a witness himself. So how do you summarize and put forward? So I prefer you to put into the headings. Okay. First and foremost, it is about the relationship of Chantek and Buntu. They are husband and wife. So such relationship will automatically pose a challenge to Chante to maintain her professional independence. So you put here rule 5, because just now you already said what, okay? And integrity while arguing the case, as she has personal relationship with Buntu. So you can use the case of Vijaya Lakshmi against Saraswati Devi. Okay, so whereby this case, the brother is trying to act for the sister. The court say no. And acting for her husband will cause her to be embarrassed and her professionalism to be impunged. Okay, as simple as that. So again, second point here, what is it has to do with the sharing of office or telephone? Okay, I will put it this way because if I am the Saudaga's lawyer, in this sort of case, I will file an application, notice of application, to disqualify Chantek to act for the husband. So the facts that probably will give doubts here is, you see, they have common pecuniary interest. Pecuniary interest here means that any interest that can convert into monetary value or profit. Okay, I will say now, both of the firm's resources are tied together under the same roof. See, using the same office, so using the telephone, they are sharing resources. Should anything happens to Mrs. Buntu Chamber, Mrs. Banga and Co. might also be affected or even suffer loss. Therefore, I will put my conclusion. As such, Chantek might infringe Rule 27, that is about the pecuniary interest, if she act in the case for Buntu. So use one landmark case here, Tanjong Marina Management against Penang Port Sendirian Berhad. Okay, whereby if you are the shareholder, you are the same person sharing the profit, the monetary interest of the parties, you cannot act. Okay, very important. So next point is Saudaga is actually Chantik's punya clients, isn't it? In the several suits. So you have to check your Bar Council ruling 6.05 here. If you want to institute a case against your existing clients, like let's say I have represent you, I know a little bit of your backgrounds and even some confidential information. Can I sue you later on in any irrelevant how to say irrelevant cases? Let's say I acted for you for divorce matter. Subsequently, you are my plaintiff lah that time. Subsequently, I act for some other person that sue you for defamation. Whether this can or cannot be done, it is actually subject to factual circumstances. There's no right and wrong. Some will say yes, some and say no. But you should have, this Chantek should have performed a conflict of interest check. So whether she hold any confidential information in her hands, which will be caught under professional privilege or not, and more importantly, will Chantek be named as one of the witness between the suit between Buntu and Saudaga or not? Because the facts itself is not so sufficient for you uh, to conclude. So you have to identify if let's say there's confidential information and Chantek herself will be called as a witness in this present suit, cannot attend. But anyhow, based on whatever you have talked about, you have to put your stand whether Chantek can or not represent Buntu. Of course, cannot lah, isn't it? So my conclusion is as such, it is best for Chantek to recuse herself from representing Buntu for the aforesaid aforesaid reason. Let's say Chantek refused to do so, she might be subjected to a disqualification application by the opposing counsel. Okay, you can refer to Dato' Azizan against Pyrain's Sendirian Berhad case. And she might also be caught for a disciplinary action for infringing the ethical rule. So better run away from this case. Okay, if you are in Chantik's position. Okay, conflict of interest is one of the very important issues in our day-to-day practice. Okay. Second question, Lobo is an advocate and solicitor, and he has successfully defended Kula Singham in a civil suit filed by his wife, VJ. Okay, so against the property value at 10 million ringgit. Lobo then issue an invoice to Kula Singham for his professional fee of a sum of 2.5 million ringgit, which Kula Singham claimed to be excessive, lacking in particulars. So Lobo then responded to say that there is an oral agreement between the parties whereby he is entitled to the sum equivalent to 30% of value of the property if he succeeds in defending the suit. Kulasingam is keen to have the invoice. So on the surface of it, it looks like they invites you to discuss about the apa nama contingency fee, isn't it? Uh, but this is not the case here. So advise Kulasingam on the following. One, whether oral agreement is enforceable or not. Okay. So we'll like our previous question, we'll examine in turn what is it all about. So my suggested answer is like this. Pursuant to your section 116 sub rule 1, okay, because you must know that Lobo is actually representing Kulasingam for a contentious litigation matter. Because I think this is a divorce suit or there's some dispute with the property which value at 10 million ringgit. So they are fighting case, contentious litigation matter. So the appropriate section that you should refer to is actually section 116 sub rule 1 of your LPA, in which Lobo must make agreement in writing, okay, with Kula Singgam about the cost pertaining to these matters. And Kula Singgam must sign the agreement. Okay, this is how it works. And you must read section 116 with 118 together. Therefore, in your conclusion, you submit that Ula Singgam is advised that oral agreement is not enforceable. So whenever you make, yeah, I know, in Contracts Act 1950, oral agreement is valid and enforceable. But when you come to the uh, solicitor and client's agreement in contentious matter, because a lot of issues about the cost, uh, if it is not well agreed beforehand, the lawyer will feel that, at the end of the day, I win this case for you, so I deserve this amount. What? The client will say this, or, oh, this amount is so exorbitant, so excessive and unreasonable. They want to reduce and discount and all that. So nowadays, LPA actually make rulings that if you want to charge your client, it's better for you to write a contract for engagement. I'll ask the client to sign. This is the fee cap like that. Okay. Mm. So question P2, they ask you to discuss what is gross sum bill and whether the same amounts to a bill of cost for the purpose of taxation. So what is the difference between gross sum bill and also bill of cost? Okay. So what are those? So actually the question, I mean the wording of it, the thing itself already explained to you lah. You see a gross sum bill you can see in your section 124 of LPA, whereby it is a brief summary of bill. Take for example, legal costs, okay, because this one is 2 million, isn't it? Legal costs, I put 1 million. Okay, and then I'll write disbursement probably 1.5 million. So total 2.5 million. So this is gross sum bill. Okay, and you can further rely on your this section 124. Okay, whereby Section 126 means that a bill of cost is a detailed version of the sum of costs which are ready for taxation. Okay, taxation we'll discuss in the next question. So that means to say I cannot just charge legal costs like that. I have to quantify. So on 1st of January 2022, attend court. Okay, attend court. I charge berapa? 5,000. So 2nd of January 2022, okay, case management or exchange document, whatever. I charge another 5,000. The detail. The detail. Sometimes the list can go on to be very long. So this is what it meant by bill of cost and also gross sum bill. But usually in practice, if the client did not argue as to the amount of legal fee, we'll give them a gross sum bill for the convenience of our clerk per se. Okay. Hmm. And third question, they ask you to discuss what is taxation and explain the process under LPA 1976. So question 3B subrule 3, I will say that number one, taxation is actually a legal process where the court examines and adjusts legal fees charged by a lawyer to their client or opposing party. It involves a detailed assessment, calculation, and formulation of legal costs. So this is a proceeding whereby if let's say Pula Singham is not happy with Lobo's legal costs, he can file an originating summons in the court, supported by affidavit, to ask the court to check one by one why this 2.5 million had incurred on this particular bill. Where does it come from? Okay. And the governing law for this sort of taxation of cost proceeding is pursuant to your section 126, section 129, and section 130 of your Legal Profession Act 1976, and also pursuant to your Order 59, Rule 12, and an or Order 92, Rule 4 of your Rules of Court. This one always people use in any other application. Order 92, Rule 7, that is the inherent jurisdiction of the court. Campur tangan lah, because it is inequitable for the such high cost, kononnya lah, such high cost to be incurred on the client. Okay. So the procedure here is how Pula Singham can actually initiate an originating summons or S plus affidavit against Lobo. So the keywords here is within 6 months after delivery of bill of cost. After Lobo had given Kulasingham what is the detailed summary of the what we call the bills, like the appearance, the case management, the photostat fee, the handphone fee, whatsoever he had done. If Kulasingham not happy, he filed against Lobo within 6 months by virtue of this originating summons plus affidavit. The law is just now, okay, 126, 129, 130, and the Order 59, Rule 7, Rule 12, and all that. Okay. And so the procedures will be just like this. The respondent, Lobo, will need to reply. Okay. And then usually the registrar will do the hearing, dengaran, and the parties are required to submit. Okay. And the assessment of the cost shall be made. And lastly, the court may issue an order how much the client should pay. And if you're not happy, you can appeal. Okay, you can appeal to Court of Appeal. Tapi susah lah, a lot of procedure. Okay, so the taxation of proceedings in real life looks something like this. Okay, so usually it's done in High Court, and this is originating summons with reference to the governing laws that I have mentioned to you. Okay, and you have to name Lobo as the defendant here. Okay, so what is your alasan permohonan? Okay, so you can name, oh, this is 2.5 million, 2.5 million following by the contentious litigation. This one is too exorbitant, too excessive, not reasonable. There's no prior discussion and all that. Okay, so you can name what is your alasan. Okay, so this is the real life scenario. And after that, you will need to submit your affidavit and all that. Then there will be a submission, hearing, submission, and then the court will issue an order. The order by the court are also a detailed one, you see or not? The order, okay? After I hear you, okay, I order so. Why I give you the assessment, also I list down in the order. Okay, so at the end of the day, the court will list down how much eventually need to pay by the parties. Okay, so this is about taxation proceeding. Is an OS plus affidavit. It's quite rumit one, this one, this proceeding. Okay. Okay, I hope you understand. Say, last question, which I really do not recommend all of you to do. This is an essay question whereby you need to read a lot. I mean, this one also quite challenging for me actually. So in the system of trial, which we have evolved in this country, the judge sits to hear and determine the issues raised by the parties, not to conduct an investigation or examination of on behalf of the society at large. As happens, we believe in some foreign country. Okay, even in England, however, a judge is not a mere umpire to answer the question, how's that? His object above all is to find out the truth and to do justice according to law. And the daily pursuit of it, the advocate plays an honorable and necessary role. Was it was it not Lord Eldon, LC, who said in a notable passage that truth is best discovered by powerful statements on both sides of the question? See ex parte Lloyd. And Lord Green, Master of Law, who explained that justice is best done by a judge who holds the balance between the contending parties without himself taking part in their disputation. If a judge, said Lord Green, should himself conduct the examination of witness, he, so to speak, descends into the arena and is liable to have his vision clouded by the dust of conflict. See Yule against Yule. Yes, he must keep his vision unclouded. It is very well to paint justice to blind, but she doesn't better without a bandage around her eyes. She should not be blind indeed to favor or prejudice, but clear to see where lies the truth. And less dust there is about the better. Let the advocates, one after the other, put the weights into the scale, the nicely calculated less or more. But the judge at the end decides which way the balance tilts, be it so slightly. So firmly is all this established in our law that judge is not allowed in civil dispute to call a witness whom he thinks might throw some light to the facts. He must rest content with the witness called by the parties. So in Re and not and Zaretsky, Bok and Company. So, so also it is for advocates, each in turn, to examine the witness and not for the judge to take it on himself, lest by so doing, he appear to favor one side or the other. See Rex against Kane, Rex against Batman, and Harris against Harris by Burkitt, Lord Justice, especially. And it is for the advocate to state his case as fairly and strongly as he can without undue interruption, lest the consequence of his argument be lost. See Regina against Clever. The judge's part in all this is to hearken to the evidence only himself. Okay, what is it more? Asking question of witness when it is necessary to clear up any point has been overlooked or left obscure. To see the advocates behave themselves seemingly up to the rules laid down by law, to exclude irrelevancies and discourage repetition, to make sure by wise intervention that he follows the points that the advocate are making and assess their worth, and at the end to make up his mind where the truth lies. If he goes beyond this, He drops the mantle of a judge and assumes the role of an advocate, and the change does not become him well. Lord Bacon spoke right when he said, patience and gravity of hearing is an essential part of justice, and an over-speaking judge is not well-tuned cymbal. Such our standards. They are set so high that we cannot hope to attain them well all time. In the very pursuit of justice, our keenness may outturn our sureness, and we may trip and fall. Denning, Lord Justice, in Jones against National Coal Board. Such a deep and profound English. Wow. And you are required to understand what he's trying to say with his, you know, with his Shakespeare type of drafting to answer the following question. A, the opening speech and the closing speech in a civil case. In fact, if you read these statements for 2, 3 times, you cannot find a single words about opening or closing speech at all. So how do you relate and how do you actually understand this statement becomes the key point. If you do not know, if you just your English is as poor as me, and you study this statement and then you are blank after reading it, don't do this sort of question. Okay, don't do. So my answer is like this. Okay. The case of Jones against National Court Board by Lord Justice Lanning beautifully, because the sentence itself is very beautiful, isn't it? So you have to show your talent a little bit, lor. Encapsulates the essence and high ideas of British legal system, where it is focused on what are the roles, you see, what are the roles played by the judge and advocates. In a very simple words, British legal system, Malaysian legal system, we are adversarial system. Means the parties, the plaintiff and defendants are fighting. You as a judge, as an impartial person, you cannot campur tangan. You cannot descend into the arena of argument. You must let defendant and plaintiff to present their case, to tender the evidence accordingly, according to the laws, of course, Evidence Act. So something like that. Okay, you cannot go. The judge, regardless how enthusiasm you have, how passionate you want to find out the truth, but you cannot go and ask the plaintiff to do, or you cannot coach them. Okay, so I will put my stand as the opening speech in a civil case is pivotal for settling the foundation of an advocate's argument, offering a clear, coherent narrative of their client's position. So, is opening speech is just like usually in any civil suit, a plaintiff will start their case. Okay, they will have to present. Usually, you will hardly see lah. This is like an old tradition. The lawyer, especially high court matters, you will need to present. You will need to, okay, my lords, this is the case between my plaintiff, Ji Huibing, against defendant, for example, Christine Lim. So this is a case about breach of contract, and I'm going to lead a few evidence here. I'm going to call two witnesses. This is the plaintiff himself and the other witness, who is the clerk of the plaintiff's firm, something like that. And we are going to tender what are the evidence. Number one, there's an agreement between the parties. Number two, there's a clear breach, so and so. What are the evidence? So you want to give the direction to the court, how you are going to conduct the case, because it's just like a drama. We have to have chapter 1, chapter 2, chapter 3. You show clarity and directions and what are the case issue here. And you want to let the judge to understand, oh, this is how you want to present later. Okay, very important, eh? Okay, so three main purpose: clarity and direction. Okay, establish a framework to the judge, and also evaluate evidence and arguments. And of course, you want the judge to direct, to focus on the facts and law that you want to present here. So this initial presentation is very important for the courts to have an overview perspective, okay, and to direct them, direct them. Okay. So closing speech is actually the last chance for the advocate to make an impact to the court. Because after calling a few witnesses and after showing the judge bundle a few thousand page of documents, at the end of the day, judge as a human being sometimes will get lost and confused. So the closing speech here is your last chance. Also, you see, in my lord, I have actually, referred to these important things, you must recall and reinforce your case strength. Okay, so this one is actually final position. Why you make up? Okay, so this is how it works, opening and closing speech. Okay, second, the order of examination of witness in the trial and whether the order may be changed by the judge hearing a case. So after Lord Denning had said in his beautiful words, all this, he's saying no. But at the same time, actually his stand is not so firm. You get what I mean? Except for the interest of justice, the judge can sometimes, but not all the time, uh, descend into the arena of the parties. Okay, he cannot assume the role as an over advocate and solicitor. But somehow or rather, it is not a rigid rule. Okay, so I will put it as such lah. Okay, since I'm just a junior, as you know, this is my humble opinion, and I will say the guiding philosophy directly influence the protocol of examination during the trial, which traditionally follow a specific order. So this is in line with our current sections 137 of Evidence Act 1950. So any party that call a witness, the said witness must have undergone examination in chief. We call it pemeriksaan utama. That means by the party that call the witness. If I'm the plaintiff, I call a witness. So usually the witness itself, the EIC, shall be done by me. Okay, if I call him. Okay, so but nowadays a lot of EIC have been converted into a written witness statement. Okay, pernyataan saksi secara bertulis to save the cost time. And then subsequently, the opposing counsel will have a we call cross-examination or pemeriksaan balas, whereby the opposing counsel will verify the testimony of the witness to counter-check whether this is true or not, and also to challenge the credibility of witness. Okay, usually this is done by leading question. Setujukah dengan saya? You have to just answer yes or no during this particular uh, apa? Time. Okay, and subsequently there will be re-examination, pemeriksaan semula by the counsel that call the witness. Okay, so the purpose of this pemeriksaan semula is to repair, because sometimes because the leading question had been asked during cross-examination, sometimes the witness will become very nervous, accidentally say no or say yes. Then actually you cannot explain during cross-examination. The re-examination pemeriksaan semula will be the chance for the counsel that call the party as a witness to repair whatever damage that had happened during cross-examination. Okay? So, kenapa anda berkata ya terhadap soalan yang ditanyakan oleh peguam, defendant tadi? Kenapa awak cakap ya? Adakah awak silap, or you said it because you want to mean something else? Okay, this is the order lah, in our court system, and you have to answer the question, can or cannot change the order. So the judge can change the traditional of witness in a trial if it is promote justice. Like I say, usually no, but sometimes in complex case or unexpected situation, the judge need to understand what the witness say. What sometimes language barrier, sometimes the way of presentation of parties, the information are simply too bulky. The judge also cannot understand what this witness is trying to say. So there's a one small rules here, section 138, rule 4, Evidence Act. The court may permit a witness to be recalled or further examination in charge, in chief, or further cross examination. The court will have this so-called right lah. But this so-called budi bicara should be used cautiously and sparingly and judiciously, not always, okay, to protect the parties' right and to ensure the trial's fairness, aim to reveal the truth, because the truth is everything, one. Okay, so this is something to do with equity principle, impartiality, and fairness. So these flexibility demonstrate the legal system and guided by the values highlighted by Lord Justice Banning. So you recall back lah, whatever he had said in the statement, okay, of the question. Oh, finally, last question. The court's control over the question that may be asked and extent to which a judge hearing a case may intervene and ask question to a witness. Okay. So more or less, so I will put it this way. Okay, actually the judge role is to seek the truth and administer justice. Okay, but however, you must be a neutral party. Like I say, this is adversarial system, isn't it? It is not inquisitory system. Like US, all that, you can see this, the recent, very famous judge, I just saw the Facebook that he got cancer. Is a US famous district judge, Judge Kiparo. He can ask witness question one. That one is different. US inquisitory system, whereby our judge most of the time shall keep quiet and listen. Okay, listen more. Okay, so the legal system is an adversarial system where the judge should listen or hear more. The judge is not encouraged to descend into the arena of arguments of the lawyers. So these philosophies here actually shapes the protocol for witness examination. And in furtherance to answer this question, so what is the stand of judicial intervention in questioning? So number one, it talks about the court's control over question. So what is the scope and limits? Okay, you cannot ask every single question, isn't it? You must ask when you cannot hear, when it is not, it is relevant, because sometimes they're just mumbling. The witness is mumbling, the lawyers probably are mumbling also. Their words itself are not clear. So the judge can ask lah, can the witness repeat the question, or the witness can close to the mic or not when she's speaking? Otherwise, I cannot hear. This sort of question the judge can. Okay, so long they are relevant, appropriate, and not prejudicial. Okay, for example, uh, if I'm the judge lah, assuming. Okay, tadi peguam tanya soalan, you just repeat the peguam soalan, and kamu cakap ya, betul this sort of question which are relevant, appropriate, and not prejudicial. You cannot ask a new question to the witness which are, okay, saya tanya awak, tadi you ada bunuh orang tak? Something like that, which had not been even asked by the parties. You cannot ask this sort of question. Okay, intervention is in questioning when the lawyers are going haywire. Sometimes lawyers also one kind, they try to intimidate the witness. They try to ask some irrelevant question. So the judge has a duty to fine-tune back the whole proceeding. Okay, then you can actually ask the intervene by asking, okay, so stop lawyer. Okay, I just need to know one question, one answer from the witness. Okay, but like I say, this should be done sparingly. So this is how the court should have control. Okay. So what is the stand here of judicial intervention is to clarify the testimony. Okay. When the judge here may actually clarify the testimony and ensure the evidence is fully understood. Otherwise, when you spend the whole day cross-examine and also re-examine the witness, at the end of the day, the judge feel like, what important information is still missing? So you have to clarify. Maybe language barrier. Most of the time, I think it's language barrier. Okay. But at the same time, the judge shall maintain neutrality and also to preserve the current legal framework and also ethical standard. So the judge is always the neutral facilitator of justice. And you must strike a delicate balance between passive observance and active engagement. Okay. Uh, at the end of the day, this is still a so-called a traditional role that should be done by the judge. Listen more, hear more, but somehow or rather, in exceptional circumstances, you can use, I mean, as a judge, you can use this power to dissent and to ask questions, okay, in order for you to maintain the integrity and the fairness of the proceeding. So this is my version of sir. Right. Okay. There's the time now. Oh, okay. So I have finished discussion. I hope you can